Hey everybody, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut. Today, what I'm going to talk about is how personal property is dealt with in a divorce agreement or in proposed orders to a court. Now, generally speaking, and when I say personal property, I'm talking about, furniture, appliances, pots and pans, things like that. Generally, the court is not going to get involved in the division of every single item of personal property. It would just be too much minutia and the court would never be able to get anything done. So there are ways that personal property are generally dealt with. I will share my screen to show you some of the standard language. So the most common language is to say that, this is a situation where two people are living together, they're getting divorced. And obviously you have all sorts of items in common that need to be split up. So the language says that the parties shall equitably divide their personal property by mutual agreement within 30 days of the date of dissolution. If they are unable to reach an agreement on the division of personal property, they shall enlist a mutually agreed upon arbitrator to assist in the division of personal property. That arbitrator's decision shall be binding, and the cost of the arbitration shall be equally divided by the parties. If the parties are unable to agree on an arbitrator, they shall retain blank, and you can insert the name of an arbitrator. Usually it's an attorney. And there are some attorneys who, have handled this in the past. So basically, if you can't reach an agreement on who's going to get what, you bring in a third party who will, sit down with the parties and, hear them out. They'll probably go to the house, see all the items, and then they'll make a decision, and that decision is binding. So that's a way to deal with it. It's very rare that people have to go to the extent of getting an arbitrator. Usually they can work out the personal property items on their own. So that's kind of the standard, but you may have in advance, a certain list of items, major items that each of you wants to keep. So what you can do is you can say that the plaintiff shall retain certain items and list the items. You can then say the defendant shall retain and then, another list of items. And then you can say that the party shall otherwise equitably divide their personal property by mutual agreement. So basically all the other items that aren't listed, obviously it's impossible to list every single item in a house. You can say every other item will be divided by mutual agreement, and you bring in an arbitrator if you can't reach an agreement. So that's another way to handle it if you have a general idea of who's going to keep what. And then there's, of course, a situation where folks are already separated and there is no, they've already divided their personal property. So in that scenario, you still want to be clear about the fact that the parties have already divided their personal property to their mutual satisfaction. So that is kind of the gist of how personal property is dealt with in a divorce in Connecticut.